Hi, this is attorney Carlo D'Angelo with D'AngeloLegal.com. I want to talk a little bit today about the process for getting a loved one out of jail on bond. If you've had a loved one who's been arrested, then they're going to need to have some sort of a bond posted before they can be released from jail. A bond is basically a monetary assurance to the court that the person who's arrested will appear when directed to by the court, will not commit new crimes, and will not pose a risk of flight or danger to the community. There are several factors that the court considers when setting a bond. One of those factors is the nature of the offense. If it's a very serious offense, then you can anticipate it's going to be a very high bond. You might need to go back before the judge and have a bond reduction hearing. That's where an attorney would be of great assistance to you in arguing that given the facts of the case, the history of the arrestee, and the other circumstances that are relevant to considering a reasonable bond, the bond that's in place is excessive. Sometimes, if it's not a serious offense, the court would consider what they call a PR or recognizance bond. That means the court is comfortable releasing the individual without the posting of a monetary bond. Let's say you've got a serious offense. You've got a bond in place. Now the process is, how do you get that bond posted? Well, you have several options available to you. If you choose, you can go to the jail directly. You can post a cash bond, which means you'll deposit the full amount of the bond with the jail, and once you do that, your loved one will get out of jail. However, if they should flee the jurisdiction, you stand the risk of losing that full cash bond that you've posted. If you instead opt to go through a bondsman, you're essentially asking the bondsman to take the risk. The bondsman will then go to the jail, they'll write the bond, they'll post the bond and release the individual, but before they do that, they're going to charge you a premium, typically 10% of whatever the bond is, plus require adequate collateral to make sure that if the offender does jump on the bail, that they'll be able to recoup their losses from the insurance company that's underwritten their bond. I hope this was helpful to you, and I encourage you to consult with a local criminal defense attorney in your area for more information on posting bond. Thank you.